Welcome back to Canadian Justice, where we're discussing government expropriation and property rights. Now, Joanna, many Canadians may be surprised to learn that we don't have constitutionally protected property rights in this country, especially when it's well known that our American neighbors do have constitutionally protected property rights. So what can you tell me about why we don't have those protections in Canada?
Well, there are common law protections of property rights. The Canadian Bill of Rights, which predated the Charter, protects property. And the historical record indicates that it's not for want of trying. The Liberal government from the late 60s intended on entrenching property rights in the Constitution, pardon me. It was the policy of Pierre Elliott Trudeau when he proposed the Charter in 1968 as Justice Minister, and then again when he was Prime Minister, when the Charter was negotiated. And ultimately, it didn't make it in. And as far as I know, the academic position is that this is both due to historical circumstances, legal misapprehensions, and just the general climate of Charter negotiations didn't make it in.
Malcolm, anything you want to add there about the history of Canada's Constitution and why property rights aren't enshrined in our Constitution? And would giving them constitutional protection give Canadians better property protections?
Yeah. So I'll say as Joanna alluded to, property rights are protected by our sort of common law constitutional tradition. This idea that presumptively owners have protections, and it's only if the legislature or parliament speaks clearly that those property rights can be taken away. But the more specific question of why they weren't entrenched in the Charter is an interesting one. The leading work on this is by Dwight Newman and Laurel Binion. They have an article where they go through the historical record, and they show that it was quite a sort of set of contingent circumstances that could have been otherwise. Certain parties, the NDP parliamentary caucus and a couple of provinces were simply more effective than others, including the Conservative caucus at the time, in advancing their views. But as Joanna mentioned, Pierre Trudeau's initial drafts supported having property rights in the Charter. It was seen as a fundamental part of our constitutional tradition. And it was just a set of sort of contingent circumstances and political machinations that resulted in it being left out. It ought to have been there, and so that does have consequences. It has consequences, of course, in the sense that you can't challenge clear legislation that deprives someone of property rights because there isn't that entrenched constitutional protection. But some have argued that the omission of property rights from the Charter has also had a symbolic value, in the sense that people have come to regard people, including judges on our courts, have come to regard property rights as somehow lesser rights because they weren't included in the Charter. And that's contrary to, I think, the intent of the Charter. Section 26 of the Charter says the inclusion of certain rights in the Charter shouldn't be taken to detract from other rights that have existed in Canadian law. And I think our courts have forgotten that. And part of what we've seen with de facto expropriation, this erosion of protections for property rights at common law, is a product of that, is a product of this misapprehension that property rights simply aren't important.
Joanna, what can you tell me about de facto expropriation in other countries? I mean, are there better protections against de facto expropriation or regulatory takings in countries like, for example, the United States?
Yeah, so of course the US does have constitutionally protected property rights, but actually losses have to be pretty severely high in many US jurisdictions before harm can be claimed. The strongest countries are actually Poland, Germany, Israel, the Netherlands, Sweden. For example, in Poland, if you're a landowner, you have the right to demand that land that is taken or adopted for public use be compensated, even if the loss in value is 1%. You have the right to that 1% compensation.
Malcolm, where does the right to compensation for expropriation fit into property rights? Is this an inherent right that we have? Is it a common law right? Mm-hmm. Is it available only when the statute says so? Where does it come from? We've got about a minute.
Yeah, there's been some back and forth on this issue in Canadian law. The CCF's position, and I think the better view, is that owners have a common law right to compensation when the government does something that amounts to expropriation. It's a common law right. So if you have a clear legislative statement by, in a bill passed by the legislature or parliament, that can take the right to compensation away. But in the absence of a clear statement like that from the legislature, there's a presumptive common law right inherent in property ownership that entitles one to compensation in the common law courts. And so our view, and I think the better view, is that it is a common law right.
We've got to go to commercial break, but we will continue this conversation when we come back.